Are you sure that Benedict loves Beatrice so entirely? So says the prince and my new-troth lord. And did they bid you tell her of it, madam? They did entreat me to acquaint her of it, but I persuaded them, if they loved Benedict, to wish him wrestle with affection, and never to let Beatrice know of it. Those words from Much Ado About Nothing are going to lead us into a case today where we learn if there is First Amendment protection for something that you think was said, but actually wasn't. And we're also going to do a case that returns to some drama from the Fifth Circuit today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Friday, June 21st, 2024, and I am super excited to have two of my IJ colleagues with me today to go through this false speech, pretend speech, whatever we want to call it, from a First Amendment case from the Federal Courts of Appeals, and also this drama from the Fifth Circuit. So with us are Christie Hebert and Rob Johnson. Welcome to both of you.
Thanks, Anthony.
Yeah, it's great to be here.
Okay, we're not going to waste any time, and we're going to go to Christie. And tell us a little bit about this. We do a lot of First Amendment retaliation these days at IJ. We actually won a case at the Supreme Court just yesterday. I should note, Anya Bidwell, our friend, she argued that case and won it, and now it's returned to the Fifth Circuit also yesterday. That's our Gonzalez case, but this is a different case with a little bit different twist in that doctrine. So, Christie, take it away.
All right, so we're going to look at Avant versus Doak, which is from the 10th Circuit. And this case is from June 11th, 2024, which will become important in a few seconds. There's a lot more to this case than meets the eye. I'll give you a quick snapshot of the facts, and I'm going to be very careful with my word choice here. The facts, at least in this June 2024 case, are that plaintiff was a truck driver for a county. The county fired the plaintiff. And the county at the time believed that plaintiff was complaining to other citizens about certain county actions. And in response for getting fired, the plaintiff brought a First Amendment retaliation claim under 1983. Notice I just said First Amendment retaliation claim. And I'm going to give you a little bit more on that shortly. So in this June 2024 decision, the 10th Circuit kind of hits 2 points. The first is in reversing the grant of, or the denial of summary judgment. So the 10th Circuit reversed a denial of summary judgment. And there were 2 points to the decision. The first is that the 10th Circuit said, hey, we don't have jurisdiction. We don't have the power to address the adequacy of the plaintiff's pleadings. So to the extent there is any challenge about the plaintiff bringing a free speech claim, we're not going to address that here because on a denial of summary judgment, that's not in our bailiwick. And then the second issue is the 10th Circuit said that the county commissioner here was entitled to that bad egg qualified immunity because the law on how to evaluate perceived speech was not clearly established. Now, it's important to note that this case, just like the one we're going to talk about in a few minutes, is a repeat offender. The first time that this case went up to the 10th Circuit, they similarly sent it back down to the district court on a summary judgment proceeding. And in that case, the court looked at the First Amendment claim, but the First Amendment claim was not a free speech claim. It was a freedom of association claim. And in response to the initial summary judgment briefing, the district court in the original case assumed there was a free speech claim based on like an implied argument that they were retaliating for free speech. So there was no First Amendment retaliation for free speech actually in the complaint here. So I think that's what's animating the background of this decision. It was originally a freedom of association case, and then somehow it is morphed over time into a free speech retaliation case. And then the other really interesting wrinkle repleting here is that through the factual record development, through discovery, plaintiff denied ever making the statements at issue here. And in the original district court decision, the district court dropped a footnote that basically said, hey, we belatedly noticed that the plaintiff is denying making these allegations. So this perceived speech issue wasn't even really part of the case originally. So it went up on appeal the first time. And essentially, the court, the 10th Circuit, sent it back down saying, hey, there's not enough factual record, there's not enough analysis here, but we are going to say that the right to be free from retaliation for perceived speech is clearly established. So you can't be retaliated against for perceived speech. But now, in this case, the court said, well, how you determined whether the perceived speech is actually addressing a matter of public concern, that wasn't clearly established at the time. So because we can't tell how you, or you couldn't at the time, we can't tell how you evaluate whether it's speech really addressing, a primarily motivated by like personal issues, and therefore doesn't get First Amendment protection in a public employment zone, or if it's something that's actually addressing a matter of public concern, which is, given protection from First Amendment retaliation. Because we can't tell what the standard is for perceived speech, we're going to say that's not clearly established. And it's important to note that at the end of this case, they don't clearly establish it one way or another, like we've seen in many cases. They just say, hey, this was not clearly established at the time. The plaintiff didn't meet his burden to show that there was a clear way for a commissioner to tell whether perceived speech was addressing personal issues or public concern. So you're out of luck. Goodbye. In concurrence, Judge Matheson, which I should note is the only judge who was on the original panel, so he's, the star of this show, he said, you know what, if you're looking at speech, it doesn't matter if it was perceived speech or actual speech, the standard's gonna be the same. That's how we address it. But for purposes of this case, plaintiff didn't meet his burden to show it was clearly established at the time. So you can see where this is going to go in the future. Folks are going to cite Matheson's concurrence, and then courts are going to say, well, concurrence, is that really clearly established or not? So I guess this is the first of many overtures in this area, but the court seems to think that it's never going to come up again because they say there's no federal court ever addressing perceived speech and the difference between public concern and personal motivation. So to be continued.
I was mystified by the Matheson concurrence, to be honest. I don't really understand why it's not a dissent.
So I think what's motivating this case is just like the poor, and I hate to say this, and the lawyers are probably going to reach out and yell at us, but like the issues are just confused because the claim wasn't raised on the face of the complaint. The perceived speech issue like develops over time through discovery. And like it seems like the parties didn't do a great job briefing about jurisdiction and, the actual precedent. A lot of it comes in response to calls for supplemental briefing. So I think at a certain point, the court just says, you know what, throw up our hands. The plaintiff loses. The plaintiff didn't meet his burden to show this was clearly established. And Matheson's saying, hey, for future reference, I don't want to deal with this case, but for future reference, actual and perceived speech is treated the same.
Yeah, it's just so interesting. I mean, Matheson's concurrence is 2 paragraphs, right? And the first paragraph's like, well, there actually are cases that deal with this. And then the second paragraph is like, those cases mean that the city should lose. But then you sort of would expect, you'd expect like a third paragraph that's like, But here's why I think that this case should nonetheless go forward. But like that third paragraph is not there, right? There's this footnote.
He drops a footnote instead. That's like basically, although I agree the plaintiff hadn't shown the law was clearly established. And then he drops another clause basically saying this is another reason why the plaintiff might win.
Yeah.
But again, I think like this is being motivated by the fact that the court is fed up with this case.
Yeah, he doesn't seem to really explain why, but you're right. I think he's just done. And maybe also he just doesn't feel like it's worth dissenting. Sometimes judges just are like, I don't really agree with you, but I don't want to make waves.
That's absolutely true. And I want to get to the heart of this case in a minute because I agree with Christie on why this case is so messed up. But judges absolutely will often not. I've heard judges say this openly, that sometimes they don't dissent in the case because they know it's not going to do anything. And it's not like they want to drop a mega dissent that the Supreme Court is going to pick up. Like, this case is not worth their time for that. And so they just sign on or concur. As we'll see in a moment, Rob, with your case, sometimes judges are just like, I don't join the opinion, but I join the result. And I'm not going to say why, because it's just not worth my time. So I think that's what's going on with concurrence. But I got to say, I try to be ready, even for cases I do not present, which is most of them on this show. I try to be ready and understand the case and contribute significantly to the discussion. And this case, until you started talking, Christie, all I really got was it was about speech that the guy said he didn't do. And so it's kind of this metaphysical, like, cat and mouse game. Like, well, what if you didn't say it? Can you even raise a First Amendment claim? But that would be absurd if you couldn't even do that, but you can for speech you did say. And so that's why I opened with those lines about Beatrice's heart and Benedict's, of course. But I truly did not understand what was the big deal. It was much ado about nothing. The guy didn't say. He says he doesn't say something, and he says it's public concern. And so that's the heart of the case. What is it of public concern? I don't get everything else. And I guess it's just because they had created such a pile of mud that the court had to do that. I mean, this seems like an opinion. The opinion's what, 20 pages? This seems like an opinion a clerk could have like shaved down into like 4 pages if they really just wanted to go to the heart of the matter and be done with it. Because like, is this public concern or not? I think probably it is. The guy says he doesn't even say it. So like what's the deal?
I don't know. I think Matheson's concurrence is like really what should have kind of been the majority in like a clearer sense. If it's perceived speech, it doesn't really matter if it's, real or not. It's the perspective of the employer. And if they thought you were speaking and then their adverse employment action, whether it's firing or whatever else, was motivated by that speech, and they perceive the speech to be something about public concern, then that's it. Like, it shouldn't be this metaphysical conversation about, what was the perception of the speech and from whose perspective are we perceiving the speech? And like, what facts are we considering? And does the context analysis change if it's perceived versus actual speech? Like, that just seems to get into like open a can of worms that you could just safely leave on the shelf.
It seems absurd. Like, I think it's better. This is a case that could have used hypotheticals. Like, as much as we sometimes make fun of dear old Justice Breyer and all his hypothetical questions or oral argument, that sometimes they're useful. So here, say the truck driver gets back to the managers that the truck driver said something like, I'm going to vote for Smith for mayor. And the manager does not like Smith. And so the truck driver is fired. And then it gets back that actually he didn't say he's going to vote for Smith for mayor, and he really doesn't care who's mayor. Actually, he's for the opponent that the manager likes. What I think it's the same First Amendment analysis, whether he said he was voting for Smith for mayor or not, right? That's it. So why do we have all this worry about perceived speech versus not perceived? it doesn't make sense.
Yeah, I think like fundamentally this gets to a big problem with the qualified immunity analysis is the level of abstraction and like how much on all fours a case needs to be with prior cases. So like if we really peel back the layers, that's the problem here, because from the big picture everybody agrees that you can't retaliate against someone for speech. Great. And then this court says you can't retaliate against someone for perceived speech. Okay, great. But then is there a clearly established rule for like what the content of the perceived speech is? No. So like it just keeps getting further narrower or more narrow on the level of abstraction because of the fact that the Supreme Court has said it needs to be so closely aligned with the facts of prior precedent. So that's the problem here.
Yeah, I think that's absolutely right. The shiny object kind of the qualified immunity where you can just kind of throw up your hands and say, oh, it's complicated and there's no case on point, like cause them to go down this rabbit hole that they didn't even need to go down. This is super frustrating. All right, well, let's stop being frustrated and instead let's enjoy a little bit of drama. So listeners will remember a couple months ago, we talked about a case from the Fifth Circuit that had a lot going on involving venue. So change of venue from a court in Texas to the District of Columbia, and the Fifth Circuit get involved in stopping that. And it's like this big challenge to this credit card rule of the federal government. And that was laid out by our friend Jeff Redford in Short Circuit 319. And we'll put a link to that episode in the show notes. So now we have the next installment of this family drama. And none other than Rob Johnson is going to explain this next episode to us.
Okay, so I'm going to try to, as briefly as possible, get through the parts that we already have discussed, and then I'll catch the listeners up on what has happened since. So this is a big case about late fees and credit cards, and basically the government reduced the amount of fees that you can safely charge as a credit card company. And so all of these big Chamber of Commerce entities, most of which are based in DC, all sue to challenge the rule. And the district court judge in the Northern District of Texas basically says, hey guys, I'm really busy. Why are you here? This case should be in DC. The case then goes up on appeal to the Fifth Circuit. And the first time around, the Fifth Circuit says, well, there was a pending motion for a preliminary injunction. That motion was pending so long that it was effectively denied. And because there was this pending motion and an appeal from the effective denial, there was no jurisdiction to transfer the case at all. So they vacate the transfer order, they send it back. And there are two, sort of separate opinions in that case as well. I'll get to those in a second. So it goes back to the district court judge, and that is, kind of where we left the story. One sort of interesting footnote. So in that initial decision, Judge Higginson had noted in his, dissent, right?
Yeah.
He dissented.
Big time dissent.
Yeah. I forgot how he had officially, captioned it. But yeah, his dissent. He concludes that by saying, this case has already been docketed in the district court for the District of Columbia. And, the Fifth Circuit has said that transfer was not effective. But, the Fifth Circuit doesn't have appellate jurisdiction over DEC. And who knows what they're going to do? Maybe they'll disregard it. So I checked the docket in DC. I was curious what happened. And Judge Amy Berman Jackson was the district court judge assigned there. And she entered an order on, it was April 10th, 2 days after she got a copy of the decision, which was entered in the earlier Fifth Circuit appeal. And what she basically says is, I'm not inclined to, quote, disregard a case on my own docket, and I have considerable discretion to supervise my own cases. So basically, I don't have to do what you said, But, she says, I have reviewed the docket and it appears that the case is now proceeding under the supervision of another district court. So, this order, she says, should not be read to express any view on the issue of the transfer, whether that's legitimate or not, but I'm going to terminate the case in the docket without prejudice. So, basically what that all adds up to is, hey, guys, if you want, guys being the government, right? If the government wants to contest the transfer and say that it was valid and litigate this issue, I'll listen to you. But if you don't want to do that, I'm just going to send this back to Texas. And that was April, and nothing happened since. So basically, the government had an open door. They could have tried to contest this, and they decided not to. So, okay.
And for those who like drama, that's an opportunity missed, I got to say, because then we could have dueling appellate courts and, oh, man. Anyway.
It would have been really fun. It would have been great. But I guess they decided this wasn't the case to do it in. I don't know why. But so anyway, it goes back down and to the district court. And the district court is then presented with this preliminary injunction motion. So the first thing the district court has to do is rule on the PI motion. And the district court actually grants it, which is interesting, right? You might have thought, oh, this judge didn't want to deal with this case because he thinks the Fifth Circuit's like too conservative and he wants to send it off to a more favorable venue or something. But no, like this is a Trump-appointed district court judge, you know, for whatever that tells you, right? And he is sympathetic on the merits. He grants the PI. I really think he's just busy, right? Like he's looking at this case. He's like, I'm busy. I got a lot of stuff to do. Why is this in my court? Like, can we just not do this, please? So anyway, he grants the PI, and then he turns back to the venue transfer question. And it's like, all right, he basically enters the exact same opinion, saying, I'm sending this off. And basically his rationale is, if you look at the docket, there's 10 law firms. 8 of them, the attorneys, are all based in D.C. The government's lawyers are all based in D.C. The plaintiffs' lawyers are all based in D.C. And if you look at the plaintiffs, it's like the Chamber of Commerce, which has its big office building in D.C. It's also all these other chambers of commerce that are not located in my court. And he says there's only one plaintiff that has any connection to the Northern District of Texas. And it's a plaintiff that claims to have standing because one of its members, it's an association, claims to have standing because one of its members is a bank that is affected by the rule, but that bank has no connection to the Northern District of Texas. So it's an association that has standing by virtue of a member that's not even in the district. So there's really no connection to this district. And he says, I don't want to deal with this. I'm sending it to DC. Goes back up on appeal, and it gets assigned this time to a different panel. So you'll recall before you have Willett writes the opinion kind of sidestepping this question of whether the venue is appropriate, on the ground that there's a PI that's pending. You have Higginson who dissents, and then you have Oldham who says, the venue is proper in the district court, and that the district court should have heard it. So it goes to a new panel, and the only person from the old panel who's still there is Willett, who had sidestepped the question, which is kind of interesting. So what's he going to do? And well, what he does is he signs with Judge Oldham. And he basically adopts the Oldham concurrence from last time, saying that venue is proper in the Northern District of Texas as the panel opinion for this new panel. Judge Haynes and Judge Duncan are also on the panel. They, interesting footnote there, right? So Judge Duncan actually joins Judge Willett's opinion. Judge Haynes, there's a little footnote that just says that Judge Haynes concurs in the judgment. So this goes back to, I guess, what we were discussing earlier. Sometimes, obviously Judge Haynes has some disagreement with what's going on here, but what that is or why, we will never know.
And it's interesting because the judgment really is a mandamus, a writ of mandamus. And so he does concur in the mandamus, which is a lot more than just, concurring in, affirming a final decision in a case or something like that. So it's, and if you are going to concur in a mandamus, you got to have some pretty strong reasons, I would think.
You would think so. But, we'll never know what they are.
Right.
And you know what? That's fine, because there are you've got a 3-judge panel. You got 2 of the judges think that these reasons are sufficient, and Judge Haynes could spend a bunch of time writing something to say something different, but that different thing would not be law and would have no real, importance other than as precedent, right? Other than to sort of tell us what he was thinking. So it's just as fine that he doesn't do that. And you look back in history, that's what judges at the founding, right? Like that's what judges usually would do. They didn't write separate opinions. They just noted if they joined or not.
Right.
So anyway, basically the rationale of Judge Willett's opinion, he says there are 2 sets of factors in the forum analysis. And the first is private factors, the convenience of the parties. And he says, this is an APA case. There are no witnesses. There's really no reason that it's harder to do it in Texas or in DC. The only difference is where the lawyers are located, but the rule talks about the convenience of the parties, not the convenience of the lawyers. And also, we're talking about a challenge to a federal rule. And if the location of the lawyers was going to be dispositive, the government's lawyers are always going to be located in DC, right? The agency counsel is always going to be located in DC. So that, if you're taking that into account, and he doesn't say this, but also the lawyers who challenge rules are typically located in DC, right? I didn't pull up the docket, but I think it's probably Eugene Scalia, right? If I had to bet, I would bet money it's probably Eugene Scalia. His office is in DC. And if it's not him, it's somebody else in DC. So, what's the, if you're taking that into account, you're always going to be pushing these cases to DC. And that's, he turns to the public factors next, right? And he basically, what he says is, reading between the lines a bit, these types of cases where you're challenging a rule that applied nationwide, they affect everybody all across the country. And the impact of the rule is nationwide. And if the court enters relief, and this is interesting, he says if the court enters relief, it's going to be a nationwide injunction. So the impact of the decision is going to be nationwide. So it's not like DC has some special interest in these cases. These are cases about law that applies everywhere. And I think Willett seems to think it would be actually pretty bad if every case challenging federal policy had to be heard in Washington, D.C., because federal policy affects the entire country. And it's not like we shouldn't have this sort of super court in the District of Columbia that gets to decide policy for the whole country. So, reading between the lines, or really not, right? Willett seems to think that it's both appropriate and actually beneficial in a kind of a federalist system, that if you're challenging a federal policy for the entire country, that you don't have to bring that challenge in DC, you can bring it somewhere else. And he says Congress, has created jurisdiction over agencies. Most statutes that say where you can sue an agency say you can either sue where you're located or where the agency is located. And Congress has made that deliberate choice. If Congress wanted to create some sort of super court for challenging agencies in DC, maybe they could do that.
And it kind of has in some cases.
Sure.
Some kinds of laws they have said you have to go there.
There are some laws that say you have to go to DC, but for the most part, agency review statutes say either DC or where you're located. And that's a choice Congress has made, and there's real benefits to that, right? People who are subject to agencies shouldn't feel like they have to march off to DC in order to challenge the agencies in front of judges who, because they're located in DC, or maybe sort of inherently view themselves as more tied to the federal government than a judge in the Northern District of Texas.
By the way, I do not see Eugene Scalia's name on the list of attorneys, but
it's such a bummer.
Maybe in the background, but a bunch of high-powered folks for the Chamber of Commerce are on the docket.
Well, Rob, I do feel for the district judge in this case, Judge Pittman. I went and looked at the stats, and there's 2 full-time district judges in the Fort Worth division that he's in, and one's a senior judge. And it looks like the Northern District of Texas is the busiest district in the Fifth Circuit. They have the largest number of civil filings in the entire Fifth Circuit. So I get what he's saying here. Hey, don't make me take this case. And I feel like I sense the frustration here, and especially, you see in the Fifth Circuit throughout with judicial vacancies and how cases are getting apportioned, and like not even just vacancies, but how population changes are driving docket changes. And so I feel for some of these judges who have pretty hefty caseloads compared to resources, and they don't have mechanisms to really change that at all. So I feel for him, but I also think, the Fifth Circuit's reprimand here that's implied in this case of like, if you're going to do this, if you're going to try to transfer cases out, you better slow roll and give us plenty of time to review is an important point too. This is the second time this case has gone up to the Fifth Circuit in a pretty rapid fashion, including this case. It looks like an overnight mandamus appeal for those poor attorneys, poor junior associates who probably stayed up all night to do that filing. And so I have great sympathy and pity for them too.
Yeah, I agree. I mean, there's a real problem here that, like, from the Northern District of Texas's perspective, they're like, everybody comes here because they think we're a favorable forum, but like, we don't want to have to do all these cases, and we have like other cases that are like our actual cases that we have to do, which I get that too. But it would be sort of strange if all of these cases had to go to DC.
Agreed.
I will just note, incidentally, Eugene Scalia does represent an amicus in this case, the Bank Policy Institute.
There you go.
So I was half right.
The most interesting part of all the drama to me is that lack of a stay. So Judge Willett says, we said last time that it'd be really nice if when cases are transferred, if you have a little bit of a stay, and that gives parties time to appeal, because this whole thing that you pointed out of the Judge Amy Burney Jackson had to show up on her docket. So maybe just push that off a little bit. And yeah, they have to file that appeal literally the same day because they were afraid of that happening again. It seems like it did, they slowed the roll after that and didn't transfer it to the docket according to what you found.
Yeah, there's a whole other drama like this too with there's a SpaceX case challenging the NLRB and the constitutionality of the NLRB's adjudication procedures. And that case, the same thing happened. It got transferred to the Central District of California. And then the Fifth Circuit had to politely ask the Central District of California to send it back, which I think they did. But this seems to be a recurring issue, especially in the Fifth Circuit, where I guess maybe it's the same dynamic that we see where you have one litigant who wants to be there, you have the government who wants to get out, and then the district court judges who are like, they're not hostile to the plaintiffs, but they just maybe are getting a little tired of having to be the nation's clearinghouse for these types of cases.
I think that Judge Willett has a good point there too, that if you're going to transfer a case, please have a little bit of a stay, not so much to give, this cat and mouse game about transferring the appeal or transferring the case versus when you actually can get the appeal on the docket, but to give a little bit of time, because otherwise you have this expedited appeal and then the court has to do a mandamus, which if there was a stay, they wouldn't have to do a mandamus. They could do a different, it's a different kind of analysis, and it's basically a more thought out procedure, and so that's going to get to the heart of the matter quicker than if they had than what happened. So I think there's some judicial management there. I will say I
wonder though, Anthony, if that's deliberate. Like, hey, let's not stay this, and maybe it won't come back to me because you have to act really fast, and you'd have to get through the mandamus hoop. So maybe that's like deliberate.
Well, I think that's absolutely deliberate, and Judge Willett is being polite when he doesn't exactly say that it's deliberate, but read between the lines, it definitely is deliberate. But I think it's a good point too. But to play a little bit of devil's advocate before we close, so a lot of these issues are kind of circling around the nationwide injunction thing. So people choose the Northern District of Texas because they think they'll get a judge there, and then they can get a nationwide injunction. And with a rule like this, this nationwide rule about credit cards, it kind of makes sense that it's a nationwide injunction. There's nothing that, the facts are going to be the same wherever you rule, and the law should be the same wherever or you file. And so it would make more sense to have it be on the same footing as all other litigants. Now, the Congress could do that by just having the court be in D.C., but like they have, as I said, with some cases, like old Voting Rights Act cases were brought in D.C., but they haven't done that. But then they have these venue rules, which you can kind of see as the will of Congress, that imply that in some cases, especially if you have no connection with the district. You really do have no connection with the district. So there's a little bit of schizophrenia there. And this does, although I think universal injunctions that cover the government from doing things to people beyond just the plaintiffs, are a very good idea in a lot of situations. And we bring them here at IJ. When it comes to nationwide injunctions, there is a little bit of a sympathy that I have with making it a more rational enterprise, like having, a multi-district court where you would randomly choose judges from around the country to give you your nationwide injunction. Or we wouldn't want it to just have to go to the District of Columbia, because then we're making the judges in that court, who are supposed to just be doing, District of Columbia stuff and boring admin law stuff, like all of a sudden get all the hot button issues. And then so much more would depend on who those judges are and blah, blah, blah. But it would be a little bit more rational than just one side picks San Francisco and Seattle and the other picks Northern District of Texas. And we have the oddness that we have today.
We already have this for, multi-district, with the panel on multi-district litigation, right? Where you have, it's like for huge tort cases where there's cases all over the country, they can consolidate them all in front of one district court judge. And you could have a similar kind of setup for these types of challenges where somebody files a case like this and it just gets randomly referred to any court in the entire country.
That's one small area where I think Congress could do its job. Congress, unfortunately, does too much of its job in many other areas, but our listeners are probably in alignment with us on that to a great degree, and we don't have to go too far into that. As long as, Congress is acting within Article 1, Section 8 of the Constitution, it's fine. But that's another story. So thank you both for coming. This has been some good drama, some good speech, and or
perceived speech.
Yeah, perceived. Well, it depends on what your perception is, dear listeners. But we'll have more for you again next time. But until that time, I hope that all of you get engaged.